My name is Matt Winchell. I'm an associate here at Tully Rinckey, and today we'll be presenting on red flag laws. So just to go over the brief top level view of this, red flag laws are contained. Sorry, Taylor, can you go to the next slide? Thanks. Red flag laws are contained in the Civil Practice Law and Rules, CPLR, Article 63A, Section 6340 through 6348. That's where you'll find everything that you need to know about red flag laws. Next slide. There's a couple important definitions that I want to go over before we get started because not everybody knows what an extreme risk protection order is, and a variety of people can be the petitioner in these types of cases. So the extreme risk protection order is a court-issued order of protection that prohibits a person from purchasing, possessing, or attempting to purchase or possess a firearm, rifle, or shotgun. In the terms of red flag laws, almost anybody can be considered the petitioner. Most commonly, it's going to be some type of a police officer, whether it's a state police officer, a sheriff, sometimes a city cop. Those are going to be who you're most likely going to see as the petitioner in these cases. But it really can be anybody. It can be, a district attorney. It can be a family member. It can be a school administrator or anybody in the school system. And then any of your licensed physicians, anything like that. You can see a fairly exhaustive list of who the petitioner can be on the slide in front of you. That the ones that are contained in D is just a huge list of every type of a medical professional that you can think of. And you can find this right in the CPLR. For the exhaustive list, but these are the main ones. So next slide, please. So the order of events is going to be similar in every single case that you're going to see. It's always going to start with an event that triggers the red flag laws. So in all the situations that I've seen, it's usually for some sort of a mental health emergency where the cops would get called to the scene. Somebody seems to be suicidal or something like that, and the cops show up. They'll 911 them or something like that, bring them to the hospital, and then after they've been brought to the hospital, one of the cops will go to the Supreme Court, ex parte, file an application for what's known as a temporary extreme risk protection order. So these temporary orders are usually good for like 60-ish days. So they're basically just there in place until a hearing can be had. So after that temporary order has been served on the respondent, that will include a court date for a final hearing. At this court date, they're going to put up the police up there. Whoever's there for the petitioner will put up at least one of the cops. If they have any other witnesses to call, doctors, whatever, they'll call them as well. That has to be done within a certain time frame. I think it's 3 to 6 business days after the temporary order has been filed. Upon completion of the hearing, there can be 2 findings. The court can issue a final order. If a final order is issued, that will be in place for 12 months. And that will relate back to whenever the temporary order was filed. So if we had a temporary order filed today and we had a hearing that was scheduled and pushed back, say a month or 2 months, after the hearing, if the final order is issued, it will relate back to today's date. So that's an important piece to keep in mind. Or the court can, in the alternative, not issue a final order and say that they did not meet their burden and the order wouldn't be issued. The respondent would be able to get their guns back. So that's kind of a quick order of events breakdown there. Next slide, Tyler. So what needs to be shown? So basically, an application is filed, and it needs to show that the respondent is likely to engage in conduct that would result in serious harm to himself, herself, or others as defined in paragraph 1 or 2 of subdivision A, section 939 of the mental hygiene law. The grounds that the court needs to consider, they have a list, but it's not an exhaustive list. Basically, any threat of violence or physical force towards self, petitioner, or other person, that's always going to be included. Violation of an order of protection, pending charges, criminal charges, reckless use of a weapon, history of a violation of an extreme risk protection order, evidence of controlled substance abuse, and the recent acquisition of a firearm, rifle, shotgun, or other deadly weapon or dangerous instrument, or any ammunition therefore. That's very broad. I haven't seen a case where that one has been alleged yet, but it would be an interesting one to see that be justified under the law. Okay, next slide. So, temporary extreme risk protection order, what does it include? It has to be issued in writing, and it'll include the following: a statement of the grounds found for the issuance of the order. So this is at the very top of the order. Basically, it's going to be just written like a support and deposition, like they would write with a ticket or anything like that. This is what you did. This is what led us to issue this temporary order. The date and the time the order expires, the address of the court that issued the order so that the respondent knows where to go, and a statement to direct the respondent, of everything that are listed on the screen, basically that you can't possess, attempt to possess, use any type of rifle, shotgun, or firearm. Okay, next slide, Tom. So the burden of proof, very low burden of proof when it comes to these red flag laws. That's really why they're so difficult for the respondent to win, because the petitioner only needs to show by clear and convincing evidence that the respondent is a danger to himself, others, or the petitioner. So unlike criminal law, for example, where it's beyond a reasonable doubt, this is just by clear and convincing evidence. So the standard, it's not a difficult burden to meet for the petitioner at all. So taking people's guns under this section of the CPLR is effective and very easy. Okay, next slide, Tyler. So the duration of the final order. The final order is a period of up to 1 year, which it's always going to be 12 months if it's directed from the court, from the issuance of the temporary order. And yeah, there it is, time frame measured from the date of the temporary order. Now there is a caveat to that. So if you're under a final order and say somebody gets 941 again, they have to go back to the mental health hospital for whatever reason, the petitioner can use that to go back to the court, file an additional temporary order, and have another hearing scheduled to extend out that final order. That becomes a real problem when somebody's being 941, like wrongly 941, they then have to go back and fight again as to why that order shouldn't be extended for another year. And it just becomes, it's very cyclic. Okay, next slide, Tyler. Now I want to spend a little bit of time on this slide because this has become an issue that was actually talked about by one of the Monroe County Supreme Court judges in a decision where they found the red flag laws to be unconstitutional, at least in Monroe County. So the section of the law reads, if any other person demonstrates that he or she is the lawful owner of any firearm, rifle, or shotgun surrendered or removed pursuant to a protection order issued in accordance with this article, and provided that the court has made a written finding that there is not a legal impediment to the person's possession of a surrendered or removed firearm, rifle, or shotgun, the court shall direct that such firearm, rifle, or shotgun be returned to such lawful owner and inform such person of the obligation to safely store such firearm, rifle, or shotgun in accordance with section 265-45 of the penal law. That is a mouthful of words. So I'll walk you through a scenario that I dealt with about 5 months ago. My client, an older gentleman, had his grandson living with him. The grandson was deemed to be a threat to himself or others. The police showed up. They 941'd him. They put a temporary extreme risk protection order on the grandson. And because the grandson lived with my client, the police went into his house, seized all of my client's weapons. I think he had about 25 of them, a mixture of, rifles, shotguns, and pistols. And they took my client's guns. So my client was not under any type of an extreme risk protection order, temporary, final, nothing. There was no legal impediment for my client not being able to possess or use firearms. But because his grandson had one, they took my client's guns. So he hired me, and we had to go through this whole process with the county court and with Supreme Court. It ended up taking, I think, about 4 months to get his guns back to him. We had to go to the Supreme Court and say that this was wrongly, his guns were wrongly taken. He did nothing wrong. He was not the subject of a extreme risk protection order. The judge found on the record that my client was able to own and possess and use firearms. It was the first time in that county that somebody's weapons were returned back to them at the hearing. It had never happened before. And it cost him a lot of money and a lot of time to fight this law that arguably is unconstitutional. And when the police took his weapons, they're like, oh, all you need to do is go back and to the court and just file the application and they'll give you your guns back. Well, that was in like October. He didn't get his guns back until January or February. So it's not as simple as many people think that it is. It's a lot of time. It's a lot of effort. It's a lot of work. So fortunately, he was able to get them back, but he missed all of hunting season. He missed a lot of his target practice competitions that he was involved in. And rightfully so, he was very upset. And in the decision from out of Monroe County, the Supreme Court judge that authored it specifically mentioned this section as to one of the reasons why, in his opinion, these laws were unconstitutional. And watching it play out firsthand, I definitely can see how it is arguably unconstitutional as applied and as written. So that's my story on that and how to handle that type of situation. Go to the next slide, Taylor. So I've put the mental hygiene law down here because the TERPO laws are authored off of the mental hygiene law. It's directly related to it, and it's not applied in the same fashion. So basically what the mental health law says that the director of any hospital maintaining adequate staff and facilities for the observation, examination, care, and treatment of persons alleged to be mentally ill and approved by the commissioner to receive and retain patients pursuant to this section may receive and retain therein as a patient for a period of 15 days any person alleged to have a mental illness for which immediate observation, care, and treatment in a hospital is appropriate and which is likely to result in serious harm to himself or others. Likelihood to result in serious harm as used in this article shall mean, now as used in this article and as used in the red flag laws, substantial risk of physical harm to himself as manifested by threats of or attempts at suicide or serious bodily harm, or other conduct demonstrating that he is dangerous to himself or others, or a substantial risk of physical harm to other persons as manifested by homicidal, other violent behavior, by which others are placed in reasonable fear of serious physical harm. So that's what the mental health law says on finding somebody a threat to themselves or others. Now, who makes the determination? Under the mental health law, the director shall admit such person pursuant to the provision of this section only if a staff physician of the hospital, upon examination of such person, finds that such person qualifies under the requirements of this section. This occurs after an observation period of no more than 48 hours. This is where the red flag law deviates from the mental hygiene law, which is where the red flag laws were authored from. Under the mental hygiene law, a physician needs to make the determination after a 48-hour hold that the person is a threat to themselves or others. A physician. Under the red flag laws, it's not a physician. It's a cop, it's a district attorney, it's a family member. It could be a physician, but I've never seen it be a physician. I've only seen it be police officers. So that's where the red flag laws deviate from where they were authored from. They were authored from the mental hygiene law, but they don't follow it to the T. So that's all I have on the PowerPoint. There were some pre-submitted questions that I wanted to get to. And then we can open it up if anybody else has any other questions.
I just want to interject really quick. If there are
Sure.
any questions from our attendees currently, please submit them via the chat so I can send them over to them. Thank you.
Okay, so somebody asked, so I am a member of the United States Concealed Carry Association, their general attorney network. I have a article that's going to be published in their next issue, the July issue. This person asked if the USCCA is able to assist with paying for legal fees. From what I've seen with the USCCA, they will, now I guess don't quote me as this being fact, but from what I have seen, they will help pay for legal fees if the if it involves self-defense. So if you use your pistol or a weapon in self-defense and you're criminally charged, USCCA will assist with paying for legal fees for that. I don't know if they cover legal fees for anything else, but that's all that I've seen. So they're a great organization, though. I'm happy to be affiliated with them. The article that I actually wrote for them is based off of a Southern District of New York federal case where the defendant in that case had a pistol in his, he was getting out of a van in a crime area that was a high crime area. The cop had said that he had recognized the van, but he did not recognize the license plate number. And the defendant gets out of the vehicle, takes the pistol out of the van, puts it in his pocket, walks inside of a deli, gets some stuff from the deli, sandwiches, whatever, comes back into the car and drives away. while the defendant is inside, the police officer that watches this happen radios another cop. They go pull him over, seize the weapon, arrest him, charge him, the whole 9 yards. The cop says, well, I knew that he was not licensed to carry a weapon because of the way that he unsafely put the gun in his pants pocket. So that raises a lot of issues, especially for people that are legally carrying weapons. If a police officer sees that you unsafely handle that weapon, if that were to be held up, they could pull you over and put you through the ringer, even though you're licensed. So it's a pretty good article. It's about 4 pages long. So if you're a member, Felipe, I hope that you check it out and hope that you like it. Okay. Somebody else asked about the changing landscape due to Bruin and the Rahimi case. I was able to read the Rahimi case. I've read it once. It's about 140 pages with the dissent and the majority opinion. I think that's going to be a good topic for another webinar because there's a lot to dive into, and I don't want to talk about it here because I need to read Rahimi again to fully digest it. But thank you for that question. It will more than likely develop into a webinar at some point in the future. Okay, somebody else asked about searching the court record that led to the serving of the extreme risk protection order. There's not really going to be much of a record. So the only thing that is going to be on the record is the temporary order, which is the application and the order itself. If you're going to try to get more information, you're going to need to figure out who's representing the petitioner. I've seen the New York State Attorney General office represent the petitioner. I've seen the county attorneys, the city attorneys. It really just depends on the police agency that does it. I think generally if it's the state police that do it, it's going to be the AG. Sheriffs are usually the county attorney. And I saw a city of Utica one where it was the assistant city attorney that was handling it. But you can get in touch with them, and they'll be able to provide you with, the body cam footage, and any other like evidence that you would normally see in a criminal trial that the cops will turn over. You'll get all of that information from them as well. The DAs usually aren't involved because it's not criminal in nature. I guess 9 times out of 10, it's not criminal in nature. It's mostly, the 939, your mental health law, in nature. It's pretty terrible. I've heard some pretty big horror stories about it. I had a potential client that was a corrections officer at one of the state facilities, and he was applying for a job with the state police, and he was in a poly, and the police officer asked him some question, and that literally threw a red flag. I think it was like, have you ever thought about killing yourself? And he said yes, like 15 years ago. They put him in handcuffs while he was conducting the poly, brought him to the hospital, went to the Supreme Court, filed for a temporary order, went to his house, seized his pistols and his wife's pistols under the whole thing. Like, it's wild, and it's unhinged at what they're doing. And Scope, I love Scope. I talked to the Oneida and Herkimer County scopes back in November timeframe. I went and gave a red flag speech actually there, and that ended up being great. Had a lot of fun. I think we ended up going for about 2 hours. So yeah, that was a good time. All right, well, if anybody doesn't have any questions, thank you guys for coming out, listening to me talk.
Thank you everyone again for joining tonight's webinar, and thank you, Matthew, for presenting. Tonight's presentation was recorded and a copy will be sent to all attendees early next week. I hope everyone has a good rest of their night. Thank you.